The rule of law has decreased in the past few years in Turkey, the most serious manifestation of which is the arrest of 2 judges, according to recent comments written by the head of the European Association of Judges, EAJ. Christophe Regnard, the president of the EAJ, which is a part of the International Association of Judges and represents 44 member associations throughout Europe, wrote to Gri Hat, an online news portal, upon being sent questions regarding the situation of the rule of law in Turkey. Finally, perhaps the more serious situation involving judges, the arrest of the judges Metin Özçelik and Mustafa Başer, he wrote. According to Regnard's comments posted on Thursday, Judges Metin Özçelik of the Istanbul 29th Court of First Instance and Mustafa Başer of the Istanbul 32nd Court of First Instance were competent to decide about the remedies to respond motions of lawyers, who claimed for the release of police officers and journalists, who had been held in pre-trial detention since months. Both Başer and Özcelik were detained on April 30 and later arrested by the Bakırköy Second High Criminal Court in Istanbul upon the request of the Supreme Board of Judges and Prosecutors, HSYK. The police officers whom Başer and Özcelik ordered to be released were accused of conducting the corruption probes against the government and certain family members of then Prime Minister and current President Recep Tayyip Erdoğan illegally, while the journalists were arrested for reporting on the investigations. Both were seen as terroristic activities of members of a terroristic group, Regnard said. The EAJ released a press statement demanding the immediate release of the 2 judges on May 29 that read, "The European Association of Judges demands the immediate release of 2 judges, Metin Özçelik and Mustafa Başer, both currently held in detention in Turkey." The 2 Turkish judges were arrested in Istanbul on April 30, 2015, after having ordered the release from pre-trial detention of police officers and journalists. Regnard also noted that the criminal offence of insulting the President of the State in the amended Turkish Penal Code, TCK, has been used against journalists and representatives of media enterprises, who differed in their view from the President and the leading political party. Regnard, individuals close to ruling party elected to HSYK. Regnard's letter also highlighted that the 2014 election of new members of the HSYK meant that individuals close to the ruling party were elected to the board. The election process was strongly influenced by the government, which established a list of candidates and promised an increase of remuneration of judges, if their candidates would win the election. The overwhelming majority of the new members are persons who had been on the said list of candidates, he wrote. The HSYK election on October 12, 2014 saw the ranks of Turkey's top judicial administrative body swell with government-backed members of the judiciary, amid concerns among judicial advocacy circles regarding the fairness and impartiality of the elections. In February 2014, urged by the immense scale of the 2 graft investigations in December 2013 incriminating some of his cabinet ministers, bureaucrats, and even some of his family members, then Prime Minister Erdoğan pushed for legislation to change the structure of the HSYK, eliciting immense criticism from legal experts and the political opposition. Erdoğan's push for the new legislation, which rolled back gains from a 2010 referendum, allows the General Council of the HSYK to convene and make decisions with the attendance of only 12 of the 22 members of the General Assembly. In addition, judges and prosecutors are now required to have 20 years of experience as a prerequisite for HSYK membership so that young judges and prosecutors are prevented from becoming members of the board. After the change in legislation and members of the judiciary who were close to the government winning in the HSYK board election, Turkey faced a flurry of decisions that fly in the face of the rule of law and judicial impartiality. An example is the arbitrary reassignment of more than 2,000 judges and prosecutors since 2 graft probes went on public on December 17 and 25, 2013, and the politically motivated investigations opened against prosecutors that act against Erdoğan and members of the government. Regnard, new court formed, no option to appeal to higher court. In reference to the penal courts of peace, Regnard said that they were in charge along with other courts of dealing with criminal matters. A court of the same type and level considers objections against the decisions of such a court, therefore, there doesn't exist any option to involve a higher instance court. The penal courts of peace were formed in June 2014, a mere month before the first wave of operations began during the Muslim holy month of Ramadan. In the year since the courts were established, the penal courts of peace have been seen as a tool for enforcing the government's wishes by way of instigating arrests based on the headlines of pro-government newspapers. For instance, when an appeal is made to a verdict of a criminal court of first instance, the appeal comes before judges from the High Criminal Court. In contrast, the penal courts of peace act as closed-circuit courts, meaning that an appeal can only be made to a different courthouse of the same level and often to the same judge who issued the original ruling. The penal courts of peace are seen to have been designed by the government to target critics and opponents by orchestrating what appear to be mock trials in politically motivated cases.